Welcome, dear colleagues, to the candidate and the public. Today, on the 28th of March 2026, the advisory group of experts has convened in full to conduct an interview with the candidate for the position of judge of the Constitutional Court of Ukraine, Sviatoslav Onishchuk. In particular, all 6 members of the advisory group of experts are present: Secretary of the AG, Marina O'Connor, members of the advisory group of experts, Yaroslav Romaniuk, Vasil Shakun, member of the AG, Hanna Sukhotska, and me, chair of the AG, Oksana Vasilchenko. Also present during the interview are 5 deputy members of the advisory group of experts: Vitaly Makhinchuk, Volodymyr Kuzmenko, Richard Barrett, Thomas Griffith, and Marek Zubik. I would like to note that we're working in a shelter, so in the event of an air raid alert, the interviews will continue without interruption. I would also like to remind you that the interview is being recorded and broadcast live on the AG's platforms and the Constitutional Court of Ukraine website. I therefore draw the attention of the members of the AG and the candidate regarding the restriction of the use of sensitive data and restricted access information during the live broadcast. Should it be necessary to discuss such matters, the AG will suspend the broadcast for that time. We are now ready to begin, so I will now hand over to Marina O'Connor, the Secretary of the AG, to introduce the candidate and remind us of the rules of procedure. Please, dear Marina, over to you.
Hello, colleagues, and everyone who is watching. As our chairman has already mentioned, the advisory group of experts will now conduct an interview with the candidate, Mr. Onishchuk. I would like to remind you that the interview is part of the candidate's assessment stages to determine their compliance with the criterion of high moral qualities. As before, each interview is allocated approximately 1 hour, and the time limit for answering the questions is no more than 3 minutes each question. Traditionally, we ask all candidates to be concise and to answer the questions clearly, unambiguously, and to the point. At the end of the interview, the candidates may make a brief closing statement of no more than 5 minutes. I would like also to note that whilst reviewing the materials on candidates, the candidate has reviewed materials that the AGE sent him with questions, and he provided written explanations, so the candidate has had the opportunity to prepare and provide answers. So now I will briefly point to the candidate. He is an attorney and a lawyer with over 17 years of professional experience in the legal field. Mr. Onishchuk, if you would like to add anything to your introduction, you may now do so for no more than 3 minutes.
Thank you. You have rightfully highlighted my main area of work. Indeed, over 17 years I have been working as a lawyer, practicing law without interruption. The only thing I'd like to say is that in the last years I have been focusing on most vulnerable groups of population. That's it.
Okay, thank you. Thank you. So now, colleagues, we will begin with the questioning. I believe that we will start with Mr. Yaroslav.
Dear Mr. Sviatoslav, good day. After you quit from the prosecutor's office, you started your practice of law. My question will be related to your income over the period of your practice of law. The AG has been interesting in the fact that from 2017 till 2018, there is no information regarding your declared assets as a self-employed person. For example, in 2017, there is only income from your work in the public prosecutor's office. 2018, the overall amount of income is 40,000 hryvnias in your law firm Onishchuk Sviatoslav, and 6,000 hryvnias from the Regional Center for the Provision of Free Secondary Legal Aid. In 2019, similar situation, 50,000 hryvnias from the law firm Onishchuk Sviatoslav, and no income declared independently as in 2018. In 2020, around 60,000 hryvnias from law firm Onishchuk Sviatoslav, and self-declared income amounts to 15,000 hryvnias. How can you comment on that? Thank you for your question. I will start with 2017. Here, it is explained by the fact that I quit the PPO at the end of 2017, and at the end of 2017, I started my practice of law in November 2017. Yes, that is right. Objectively, I should indicate, and that is going to be the truth, that at the end of 2017, 2018, and 2019, it was my period of learning the basics of this profession, and my understanding that was being shaped how I should work, because I saw that the organization of the work and independent work as an attorney, even if it was the law firm as a corporate entity, but that it was me who I was the founder, and I was the only attorney there. It was different things. So it took me a lot of time to get adjusted, to find the clients, and what was more important, to establish our business processes with the clients, because all clients are different individuals, and it's not always easy to develop such clientele. At the same time, I started working with the Free Legal Aid Center at that point. So yes, indeed, in 2017, I didn't get income from my own individual practice of law. I had just started working for the Free Legal Aid. I have been through the competition, I was selected, and what I had is the income that was mine at the point when I quit. But what about 2018 and 2019? In 2018, yesterday, I received some clarifications from the tax services. Unfortunately, I was able to send it to you only yesterday evening. I was able to establish the real amount of my income of the law firm. So it was 140,000 hryvnias, and etc. The information that I have indicated. So over the years of the practice of law, I already have this information, and now I am presenting it to you. That is the amount that my law firm was getting. So the question is related to your own income, not just the income of the law firm. So when we speak of my own income, apart from that of the law firm and the one that the law firm got from cooperating with the Free Legal Aid Center and with the clients, I didn't have any other individual income, because I was concluding agreements for the representation of the clients through my law firm. Dear Mr. Sviatoslav, after we analyzed the Unified Register of Court decisions, we saw hundreds of judgments where you mostly were involved in criminal proceedings. At the same time, from 2017 till 2020, the official income that you have received over 4 years is 100 63,177 hryvnias. How can you comment that? And from the standpoint of the reasonable observer, can such a reasonable observer have the impression that you concealed your income in order to evade taxes? Please comment on that. Thank you for your question. In order to objectively assess this situation, we must understand what kind of cases those were. The thing is that starting the end of 2017 until now, the majority of my cases, in particular criminal proceedings and civil cases, those are the cases where I represent the interest of my clients upon the instruction of the Western Interregional Center for the secondary free legal aid. Those are not my clients who pay the fees. It's not even 30%. No, we speak of the period from the 2017 till 2020. Yes, exactly. You started working in the free legal aid in 2021. No, my first agreement was in 2017, and I started working with them from that very year. First, it was with the law firm, because that is the form of activity I chose, and then later as self-employed person without interruption. In 2017 I didn't have a chance to conclude an agreement with them, because only in November I started doing this free legal aid, but then I have been working without interruptions with the free legal aid. First it was in the Rivne region and the Rivne Center, and now it's Western Interregional Center for the provision of free legal aid, secondary free legal aid, and mostly those are the free legal aid cases. And not to have any doubts for the reasonable observers, it's impossible to hide those assets, that income, because it's the payment of the services from the budget that is done based on the acts of the services provided, and based on the contracts. It's open, and every hryvnia that was paid by the state for my work goes through the bank account. I only was able to provide all my bank statements starting from 2021 for you to see that the majority of my income is the free legal aid. I will explain why there are so many of them, if that's important for the AGE.
Mr. Sviatoslav, we've communicated with you previously. We've asked questions to you within the first round. Within the second round, you provided your answers. You provided documents in order to clarify the situation. And we established that starting from 2021 until 2025, you have participated in 229 cases through the free legal aid system. We asked for the confirmation of that. However, you provided us with the documents confirming 20 cases only. I will explain why. When I was providing only 20 orders confirming my participation, I suggested that the purpose of that request was to confirm that I was genuinely involved with providing services within free legal aid system. So I didn't think that I was supposed to confirm my participation in all of the cases. As I told you previously, I work in the Rivne region, working for the interregional department of the Ministry of Justice. So in my activities, I cover mostly the Rivne, the city of Rivne and Rivne region, populated by some 30,000 people. Now the population has grown up because of the militaries, because of the internally displaced persons. So back in 2018, there were 3 lawyers providing free legal aid services in that region. Currently, I'm the only one to do that. For some reason, such activities are not very much popular among my colleagues. Well, I can tell you the reason. It's because it comes to representing the most vulnerable layers of the society. Now, going back to my income and to why it is so low, you can check the existing rules on remuneration on free legal aid advocates. There are all the tariffs, all the fees, which are quite low. Besides, the payment is usually done by installments, so the trials may last quite a long time. However, you get your payment at certain stage, so you may intervene in various court hearings, in various cases, but you get paid at a certain moment in time in the future. This is how the free legal aid system works. And again, coming back to the tariffs, to the fees, they are quite low. Besides, not all services provided by the candidate are even paid. So there is like a calculator which applies for the a scheme which is applied for calculation of the remuneration, but it does not take into account all of the activities exercised by the lawyer when representing his clients within the free legal aid system. Unfortunately, this is how it is. Unfortunately, the tariffs cannot get higher because, as I told, there is a calculator and there is public procurement of services. Thank you. Within the written rounds, we asked you to indicate your income over the years of practice of law. You provided indeed information and confirming documents. However, the figures do not match. For instance, in 2018, you declared an income of approximately 80,000 hryvnia, but according to information received, your total income amounts to 40,000 hryvnias. In 2019, you declared 120, while confirmed by the documents are 50 hryvnias. In 2020, you declared 160,000 with confirmed almost 90,000. In 2021, you declared 200,000 but you managed to confirm only 100 hryvnias. In 2022, 220,000, while you managed to confirm 215,000. In 2023, 240 confirmed 175,000. In 2024, 260,000, while confirmed are only 163,000 hryvnia. Could you please explain these discrepancies? Thank you very much for this question. So you operate with so you give me official figures, and I can confirm them when filling in the declaration. I was not aware of the exact amount of my income, so I would indicate some approximate amounts. And as you can see, with years, the precision is getting higher. So I've been operating with some approximate figures, and when doing so, I would rather indicate higher amounts so that nobody thought that I was hiding my income. I understand that it was not the best practice, but this is how I believed it right at that time. My next question is about the payment of the unified social security payment as a self-government person. In 2025, in 2018, the law came into force, which allowed self-employed persons not to pay the unified social security payment in case if such a payment is done by an employer of such a person, provided he or she has an additional activity. However, until 2018, all self-employed persons were supposed to pay the above-mentioned social fee. Why wouldn't you do that when starting practicing law? Thank you. In I started paying this fee starting from 2021. And I can give you amounts by years. I have them in the statement which I have on me today. Before that, it was the law firm, my law firm, which paid that unified social security fee. Why wouldn't I make this payment by myself? It is because the legislation was unclear on that matter. At that time, there was no unified interpretation, and I suppose that if I am a founder and an executive officer of a law firm which I founded, then this payment can be done through the law firm. I would consult the tax authorities in order to make sure that I got it right at that time. I wanted to make sure that I wouldn't have any taxation debt or any problems with the taxation services, and they confirmed that it would suffice to have the law firm to make this payment for me, and I have these statements from tax authority services confirming that I don't have any indebtedness or outstanding payments for the years in questions. And then I clarified with the tax authorities whether I was supposed to make such payments as a self-employed person, as a self-employed professional after the legislation had changed, and they told me that I was not supposed to do that. Thank you. The next question from my side then. It is about the operation of your law firm starting from 2018 until 2025. So after making such an analysis, we've identified that the income constituted 350,000 hryvnias. You, as a manager of the law firm, obtained 158,000 hryvnias as a salary, which means that you would obtain a minimum salary, and it was you who actually decided on the amount of salary. So my question is, why would you establish, or why would you decide to pay a minimum salary to yourself as a manager of the law firm? I will explain. So if you look at the figures, at these figures today, the logic might say that I could have established a higher salary to myself. But if we have a closer look, if we take into account that the law firm basically consisted of one person, myself, who was a manager, who was the only employee, because I didn't have any other employees except for myself, then one may realize that the majority of my income as a self-employed professional and as a manager of the law firm for the maintenance of the law firm and for covering the expenditures. So the amount that you have, 350,000 hryvnias, this is the total income obtained by the law firm. But I had to pay utilities from this amount. I had to buy fuel for my car in order to be able to travel across the districts which I covered by my activities. All the correspondence of the mailing expenses were exercised at my cost. So, if you take all these facts into account, and besides, if you know that the payments for your activities come once every 6 months or even less often, then the logic seems to be quite substantiated. Unfortunately, it functions like this. You provide services, but then you need to wait for your payment because it is dependent on the budget. But in the meantime, you still need to pay utilities. You still need to buy fuel for traveling. You still need to maintain yourself and your family. And again, if you take into account all the above, you may understand that I could not establish any higher salary for myself. So this is the logic behind it. I would say that 80% of my income from free legal aid are used to cover expenses that you bear because you cooperate with the free legal aid system. There is no other way if you are really willing to provide high quality services to your clients.
Для прикладу, у мене
And that requires certain expenditures. For example, right now in the pipeline, I have 5 cases of the military officers that are held in the pretrial detention center in Rivne, and every one of them requires the attention of the lawyer. And it means that you have to go to each of them, to meet with them, to get their explanations, to agree on further plan the defense strategy. It's all time and it's all the expenses you have to make, but nobody compensates that. Okay, I see, Mr. Sviatoslav. So that is why you set the minimum salary for yourself. Yes, that's right. Next questions will be related to your collections. So you're a person who collects some items, right? I collect only the items for writing. I collect fountain pens and roller ball pens. Do you have a big collection? What collection? Whether you have a big collection, how many items do you have? It's not permanent for me, for as a person who's collecting things. So you buy something and you sell something. It's not how it always happens. So we either exchange some items. In some cases, we sell some items as well. Mr. Sviatoslav, the AG has paid its attention to the fact that in your declaration for 2025 that was amended, you indicated that there was some property alienated, and you explained that it's the amount from the items you sold while collecting these pens. What is the amount? Just give me a moment. I will look it up. Let me check. I sold 2 pens. One was Montegrappa Venezia, and another was Visconti Skillerton. The first I sold, if I'm not mistaken, around 40,000. Another around 20,000 hryvnias. Yes, of course, hryvnias. How do you manage with such a small official salary? Be collecting of such expensive pens? I will explain it to you. To explain to you how I make it possible, you need to feel the specifics of this type of collecting. As a general rule, me and similar enthusiasts, we don't collect new pens. For example, they said Montegrappa Venezia was issued back in 90s. It's not new. I bought it when it wasn't new. Yes, it costs around 40,000 hryvnias, but I bought it for $200 in if we take the equivalent. For that, it took me 2 months of bargaining and arguments why he should decrease the price, why this is more important for me than to him, than restoration, because it's made of silver. So you need to know how to polish silver, how to make sure that it looks presentable, etc. And quite often, for example, the collectors take some fountain pens that need to be refurbished in terms of this writing instrument, this fountain pot that is most valued in this case. Therefore, the value can be quite big, so the price can be quite high. And for those who are working in this area for quite a long time, who are interested in these matters and is a real enthusiast and is up to speed, knows where to look for those pens, where we exchange. Some we don't always sell, we sometimes exchange, and in that network one can get a pen many times cheaper. As a general rule, I don't spend more than $300. So why I'm giving the dollar equivalent is because most often the enthusiasts are also from abroad, and in Ukraine there aren't many people who have a hobby like me. Therefore, I am giving you the euro equivalent or dollar equivalent. In Europe, there are a lot of people who are interested in this collecting, so that is part of the history that I like very much. Thank you so much, dear Sviatoslav. It's not all questions from me, but for now I will hand over to my colleague to Marina Connor. Dear Connor, over to you, please. Dear Marine, over to you.
Ми вас не чуємо.
Dear Marine, we cannot hear you.
I'd like to ask you some questions about the acquisition of your lawyer's license. Now, according to your curriculum vitae and the information in your employment record book, on the 3rd of November in 2017, you were dismissed from your post as a prosecutor in the Costopol Department of the District Public Prosecutor's Office. And at the same time, according to the information in the Unified Register of Lawyers of Ukraine, the very next day, on the 4th of November 2017, you received your license number 1307, granting you the right to practice as a lawyer. While you were, what were the circumstances surrounding your dismissal from the prosecutor's office and the granting of your license to practice as a lawyer?
Дякую вам за запитання.
Thank you for your question. I will start with the second block of your questions regarding the circumstances when I quit the PPO. Indeed, in 2017, I personally made a decision to quit the PPO. It wasn't related to any pressure or any misconduct on my part. Quite the contrary. I was trying to attach to my explanations all the documents that would pinpoint the fact that even prior to me quitting, I was one of the best workers. I was given commendation letters and I was decorated with many letters testifying to my good character and diligence. I was one of the best workers of the prosecutor's office, and I was included in different talent pools. It couldn't have been the case had I not demonstrated my professional diligence and proper execution of duties as a prosecutor. But objectively, when the person is poor, and I consider myself to be the one that if I don't feel development in a certain area, I decided to have another stage in my career. That was my decision, that was planned, that was done quite thoroughly. Therefore, almost without interruption, I was able to quit and to continue my practice of law, but as a lawyer. And why I was able to do so, because as of the year 2017, I have attached a respective confirmation. The position of the National Ukrainian Bar Association was that if a person wants to get the lawyer's license, the person has the right to undergo internship while still maintaining his or her main job. Of course, it was regarding judges, law enforcement officers, whether they can combine internship with holding their current positions, and the Ukrainian National Bar Association has provided the clarification that they can undergo the internship, and they were not able to get the lawyer's license while still being in another position. Right now, the situation has changed a little bit because of the jurisprudence, but back in 2017, it was the case. At the level of the Ukrainian National Bar Association, it's allowed to undergo internships, and by the way, there have been no official objections, neither from the judiciary nor from the prosecution. There were no impediments for that. Therefore, I started my internship still while occupying the position of a prosecutor. I have completed it, and only after I quit, I was able to get my lawyer's license to prevent any conflict of interest.
And let me ask you, with which lawyer did you undertake your internship? And what tasks did you perform during the internship?
I was doing my internship with Jana Olehivna Zdrajevska. This is a lawyer with who prior to my internship we've never had any relationship, neither professional nor personal. We've not been in contact regarding any cases. Jana Olehivna is from Rivne. At that point I was working in Kostopil district, so we did not have any cases in common. And I got this lawyer as the one with who I was doing internship by the National Ukrainian Bar Association. Nobody asked my opinion. I was just offered this mentor. This internship mentor. I agreed, of course, because for me the goal was to undergo this training and not to look for somebody who would be more convenient for me to do internship with. What were the tasks? There were different tasks, in particular participation in court hearings together with the lawyer, but I was able to do it while I was on leave. I have also provided you with this information that while I was on leave, I was able to do that. Regarding the preparation of different procedural documents, criminal, civil, administrative area, I did that on my own within the time limits provided for by my book of internship. I did it outside of my main working hours because by that time I already had quite extensive experience in this regard. And of course I have uncovered some new information for me because my work as a prosecutor was more related to the area of criminal legislation, and the civil and commercial jurisdiction was something new. Therefore, I have made some new discoveries for myself there. That was the circumstances of my internship.
Could you tell me, how long did your internship last? How long did it take you?
It was 6 months.
And you mentioned that you did attend court hearings, but you were on leave when you did that. Is that my correct understanding?
Так.
Yes, indeed.
In your opinion, could the situation in which you were serving as a prosecutor at the same time you undertook this internship with a lawyer raise any doubts or suggestions in the mind of an impartial observer that there may have been a subordinate relationship between you as a prosecutor and that lawyer?
На мою думку, ні. На то є.
In my opinion, no. The answer is no. At that time, we would exercise our professional activities in 2 different districts. We have no case on our portfolio in which we would have conflict in interests, where we would represent different parties, or where she would intervene as a defense lawyer and I would intervene as a prosecutor. I attended court hearings mostly on civil and commercial cases while doing my internship. While as a prosecutor, I would deal with criminal cases. Besides, while I was attending the hearings. There were also students of law departments who would come there in the framework of their training, and I also attended those hearings as a third party, just to be there and to learn something. But as I said, there was no relation between myself and my supervisor.
Now, let me ask you about another area in your declarations. According to the information in the Unified Register of Lawyers of Ukraine, on November 4th, 2017, you received a certificate number, as we said, 1307, granting you the right to practice law, and you are a member of the National Bar Association of Ukraine. Furthermore, in your electronic declaration for 2015 to 2017, you stated that your registered place of residence is a property located in the town of Kostopol, Rivne Oblast, and that your actual place of residence or the postal address to which the National Agency for the Prevention of Corruption may send correspondence to you as a declarant coincides with your place of registration. At the same time, your declarations for 2015 and 2017 contain no information regarding any properties you use for residential purposes or which you own, and your declaration in 2017 and 2024 contain no information regarding your membership of organizations or their bodies. How do you explain this, and why did you not include the information in your declarations in accordance with the requirement of the anti-corruption legislation?
Дякую за запитання.
Thank you for this question. So again, the period covered by my declarations submitted as a prosecutor. So at the time, I would live in the dormitories, and I have a room in the dormitories. If I submitted this declaration now, I would indicate that property. But at the time, as a young prosecutor, I would rely on what my hierarchy told to me, and they would say that it was up to them to decide where we should live, either in the dormitories or in the official residence. So since it was decided by my hierarchy, I didn't have any contract which would confirm my right of use of the above-mentioned property. Today, I understand that I should have indicated that I should have included that property in my declaration, because I would live there indeed. But as I told you, unfortunately, I don't have any documents confirming my right to use these real estate objects, the dormitory and the official residence in the city of Kostopol.
I'd like to draw your attention then to the regard to your studying abroad. Since 2024, you have been studying remotely at the Universidad Internacional de La Rioja in the Kingdom of Spain. Please specify which educational program you are studying and in what format it takes place, and how do you balance your studies with your work or your professional duties?
Так, дякую за запитання, звичайно.
Thank you for this question. I will answer in details right now, starting from 2024 until today, I've been studying remotely in the above-mentioned university, Universidad Internacional de La Rioja, in the Kingdom of Spain. So this university provides 100% training. They mention this as their advantage on their official website. Basically, that was the reason for me to choose this university, because considering well-known circumstances, I cannot predict when I will be able to go freely abroad and to exercise studies. This university provides for the opportunity to get trained fully remotely. All the examinations are passed remotely. They make all the arrangements, this double control system with cameras being on during tests and examinations. They provide their services to the students all over the world. The university is certified by the Kingdom of Spain. It is through this university that I improved my command of the Spanish language and obtained my B1 diploma in the Spanish language. I study fully remotely, and this is a huge advantage for me. How I combine it with my professional activities? Well, the answer is simple. The format of study provides the students with the opportunity to complete practical tasks at any time. There are deadlines set, of course, but other than that, you are free to complete these practical tasks in the evenings or during the weekend. The examinations are mostly scheduled for the end of the week or alternatively for the weekend. I tend to choose weekends because this is easier for me considering my workload. The examination process takes place under control with the use of two cameras, front camera and side camera. So the university has full control of me and of my academic integrity. Besides, the lectures are mostly delivered in the evening time. It's 8 or 9 o'clock p.m. Kiev time. So I usually have the possibility to get connected. But if not, all the lectures are recorded and stored on a special dedicated platform, and everybody can have access to this platform in order to hear the lecture at any time. This is how I managed to combine it with my professional activities without any particular problems.
Would you specify which educational program you are studying? And you say it takes place in the evening and it is done remotely, but what is your course of study?
Право.
Grado de Derecho, it's law. I study law.
Так, право, derecho.
Yes, it's a law curriculum, Grado de Derecho. This is the name of the program.
Оплачую я зі своїх.
I pay this training using my personal savings, but there is an intermediary person, a Spanish citizen who pays, makes actual payments for me. Why not directly? Why don't I do it directly? So the payment through bank transfer can only be can be, so if a student is willing to pay studies by installment, then such a student is supposed to have a bank account either in Spain or in any other EU member state. Besides, if you make it through a bank transfer, you can first thing do it by installment, and second thing, you get a discount. As a Ukrainian student, if I would do this transfer from Ukraine, I wouldn't have these advantages. That is why I asked my acquaintance to do it for me.
Of these studies.
Вартість навчання.
So the cost of studies for academic year 2024-2025 is 3,316 euros and 1,800 euros for the academic year 2025-2026. So why this difference? It's because I chose less credits for the latest academic year, so I overestimated my my forces in the first year of studies, and then at some point in time I realized that it was too much for me, because the training is delivered in a foreign language. I had to learn a lot of terms in the Spanish language, and that is why I decided to decrease my workload for this academic year.
To study specifically in Spain and at this university.
Thank you for your question. First and foremost, I didn't set the goal to choose Spain. I was thinking of getting a degree in the EU. Why? Because while I started working as a lawyer, and right now I'm facing the fact that a number of my clients who export goods, they somehow or other come in contact with foreign counterparts. Therefore, I had several situations when the Ukrainian entrepreneurs requested some legal support in the territory of the EU, and I saw that despite my knowledge and experience, given the lawyer's monopoly, and as evident, it's getting even stronger than in Ukraine there in the EU, even if I understand the content and I know how it should be formalized and effected without having the respective license, lawyer's license in the EU, I cannot lodge any documents and motions related to the case, because only a person from the EU with the license, lawyer's license in the EU, can do that. So I understood that in order to build my career further in this area, in particular international arbitration and the courts of European Union countries, I need to get a respective education in the EU, and only then can I expect to be recognized as a lawyer there, at least to have to be able to lodge some motions, some procedural steps that I'm requested to do as a lawyer. By Spain, in Spain, I found that university that is 100% remote, and only then I have the acquaintance who can really help me with making these tuition payments. And thanks to such approach, I was able to save up to save some money and to make the official payments and to learn remotely. And I decided that the knowledge of Spain, that is one of the most common one in the EU, it would be a good match for me. That's why I chose Spain.
Did the amount of the financial transaction related to the tuition fees in 2024 exceed the threshold for significant changes in financial status as defined in Part 2 of Article 52 of the Law of Ukraine on the prevention of corruption? And why did you not include this information in your electronic declarations?
One of the payments, not of the payments, but wires, these transactions that I made on the 22nd of August 2024, 3,316 euros was to a little extent just by 800 hryvnias is over the threshold that was subject to declaring. So formally I should have reflected that in my declaration, but I didn't do that, because of this circumstance that this threshold is that small that it didn't catch my eye. And the second thing is that I was expecting it subjectively confirmed by the documents that this payment is actually divided into 12 small payments, and that's how I saw this situation. But then I understood that I should have been assessing this as a single payment, even though it was reflected as minor payments for 12 months. But I please bear in mind that I didn't have any evil thoughts in mind, so it wasn't some deliberate actions on my part that would be in contravention to the law. So in my conviction, it doesn't indicate my intention to hide anything.
All right, now I'd like to direct your attention to some activity regarding the defense of your brother. According to information from the Unified State Register of Court Decisions, in case number 688-2380-16K, it was pending before the Sviatoslav District Court of Kernostepki Oblast on 29 October 2020. In that, having considered in open court the criminal proceedings that happened on December 7th, 2015, concerning the charges against Serhiy Volodymyrovich Atarmovnev and Petro Onishchuk for committing a series of criminal offenses, decided to approve the plea agreement that was concluded in October of 2020 between, he was found guilty of committing the criminal offenses that under Part 2, Article 15, Part 2, Article 201, Part 2, Article 28, Part 4, Article 321, etc. And the sentence was imposed upon him. Now, please explain the circumstances of your involvement in the aforementioned criminal proceedings as a member of the defense team.
Дякую за запитання.
Thank you for your question. Indeed, that fact happened. In the first exchange of written documents without even receiving such questions. I drew attention of the AG members because I think that this information is important and requires the assessment of the AG, of course, even though it's not related to me personally and related to my brother, and through the prism of my functions. Indeed, my brother had this situation in his life. I was acting as his defender. I couldn't choose any other way to proceed because that is my brother, and had I refused to provide defense to him, and had I distanced myself from this situation, even though I had nothing to do with it, I couldn't consider myself to be a normal person, because it's one of the closest persons to me. Therefore, I acted as a this defense here. So I told him that I'm providing the services free of charge, because I understand that he doesn't have a chance to pay for the lawyer's services, and nobody is going to defend him for free. Therefore, at the level that I was able to provide, nobody would be doing this. Therefore, I officially took on this case. I used all the tools provided for by the legislation for me as for defender. In order to mitigate his position, I was contributing to the conclusion of the plea deal between the parties. It was a long process. But it is officially done. It was officially done. That is provided for in law, and as a result, my brother, first of all, was held accountable for the unlawful actions that he had caused, and I was in no way looking for excuses to make sure that he would evade responsibility, but as a defender, I complied with my duty, and I used all the leverage in the law in order to mitigate his responsibility, because he's a young man and he has his life to live, and I am convinced that he can be reformed, and I see that right now it's actually what happened. Now he's an entrepreneur, he makes official money, and my involvement was free of charge. I didn't get a penny out of it.
And you have never, your brother has never paid you for legal services then, for this or any other?
No, I've never received any payment from my brother. My brother didn't pay me any money.
Great, thank you. Mr. Yaroslav.
Дякую, пані O'Connor.
Thank you, Ms. O'Connor. I'm going to have a couple of questions to you. First one is related to the fact that from June 2010 till May 2012, you lived in some housing. You didn't pay any rent. It was a room of one of the barrack-type buildings in the town of Kostopil, and as you stated, it was based on a verbal agreement with the owner, without any contracts being signed and without payment of rent, in exchange for maintaining the dilapidated premises in a habitable condition. At the same time, according to the information received by the AGE, you owned a flat with a total area of 28.7 square meters at the above-mentioned address, the ownership of which you terminated, and this flat was alienated by you on the 12th of July 2012. So why did you hide the fact that you used to own a residential area at that address? Thank you for your question. It is this very flat, number 2 in house number 20. It is the same flat. So the right of ownership and the right of the use of free of charge owned by another person, those are different things. Yes, so you're right. I will explain to you why this discrepancy arose. I had no intention of hiding this fact from the AG, and objectively, when I was filling in all the questions, I was, as far as I remembered, it's been some time, I was basing myself on the will with the previous owner in 20. She was planning to consider to give me this flat because she considered myself to be my grandson, because I had been supporting her, and she was a woman who's living alone. And after the clarifying questions by the AGE, I did remember that this fact happened in 2007. Natalia Soko suggested that it not be inheritance but the purchase and sale agreement. I wasn't very impressed with that, but she wouldn't take any money from me in any other way. But Mr. Sviatoslav, you are a lawyer, you are a prosecutor, you are a defense lawyer later, but then do you see the difference between the sale and purchase agreement and the contract for the use of premises free of charge? But free of charge in this flat, I was living there in this flat free of charge, and the fact that it was later given me as ownership based on the contract of purchase and sale, but I wasn't actually the real owner of that. I became the real owner after her death, and I didn't I didn't have any need for that flat because it was dilapidated. There were no central utilities. Also, it was very small. Therefore, I sold it. But for a long period of time, I was living under a condition that I would keep it in a habitable condition. Okay, I see. If from 2020 you own a flat square that has the area of 67 square meters, and the declaration for 2024 you indicated its price being 2,700,066 hryvnias, for which you acquired ownership on the 19th of February 2020. How did you determine the price of that flat? It was through the official assessment on the website of the State Property Fund of Ukraine. Everybody can use this option. And let's say that a person who is an owner enters the location, the parameters, the square meters, and the total area, and the year when this property was actually made operational, and the State Property Fund provides an official certificate that I have attached. Okay, thank you. Next question. In your case, you own 3 land plots, and your mother also owns 1 land plot. In what way did you acquire ownership of these land plots? Was it the deeds of gift, purchase and sale agreement, privatization? How did you acquire ownership, and how are they used? Because the AG has been looking at the fact that your mother leased that land plot, but there is no income declared in respect of that lease, and no taxes are paid. So do you have anything to do with all these circumstances? Are you involved with the acquisition and disposition of these land plots owned by your parents? How are you connected to all of that?
As to my mother, Nadia Onishchuk, it is true that she owns a land plot of 2 hectares starting from 2021. She privatized that land plot. It was a free of charge transfer of a land plot to a citizen. The land plot is located in Yunakivska territorial community of Sumy region. In 2021, when my mother obtained that land plot, my mother would sign a rental contract first, because the land plot is located in Sumy Oblast, but while my mother lives in Rivne Oblast. Why in Sumy Oblast? I will explain now. So in 2022, the full-scale invasion started, and as of now, this land plot cannot be used by anybody, because it is located in close proximity to hostilities. So my mother wouldn't receive any income from giving this land plot for renting this land plot, because the person who rented the apartment wouldn't pay anything for this land plot, because he cannot use it actually. But my mom pays a land tax for this land plot every year. So why Yunakivska territorial community in Sumy region, while my mom lives in a completely different region? It is because she was born there. So this is the Sumy region. People know my mother. They remember her. So many of members of the local council know my mother as a friend or an acquaintance of their parents. So this is how she actually obtained that land plot. I actually never got into many details in relation to this matter. I have nothing to do with that deed of obtaining this land plot or of privatization, because I worked as a prosecutor in Rivne region, and I spent all my professional life in Rivne, so I couldn't exercise any influence or somehow push the local community to give the land plot to my mother. As to my father, it is true that he owned 3 land plots in accordance to the explanations that I received from my brother. My father would obtain 1 land plot, and then 2 more land plots were inherited from Miss Natalia Sobko, who I mentioned previously. So the land plots were given by Miss Sobko to my brother, and then my brother would give it as a gift to my father. So 1 land plot is intended for housing, so on the residential house can be built on this land plot, while 2 other land plots could be used for agricultural purposes, but actually none of the land plots is used in accordance with its destination. Let me ask you another question. So in 2015, so It coincides with the beginning of the anti-terrorist operation in the east of Ukraine. So could you please explain this coincidence? There is no coincidence. So it's true that I obtained my military service card in 2009, but when in 2014, when the ATO started, I, as an officer, was invited to the military unit in order to undergo the health check. Why wouldn't you undergo medical health check after the beginning of the full-scale invasion? Because I was never asked, I was never called to the territorial military registration and enlistment office to undergo this medical check with the medical commission. So are you excluded from military service, suspended from military service for now? Yes, I am. So you got suspended from the military service in the beginning of 2026 when you got employed with Dubava LLC. So was it for the purposes of having this deferral from conscription? No. Actually, it is my additional activity, professional activity. So Dubrava LLC is located in a different region, different from where I work. I decided to expand my professional activities. That is why I got into relations with professional relations with this Dubrava LLC. I didn't know that they may provide this deferral from conscription. No, I didn't know. I have another question regarding 2022. In accordance with the information that we have, in August 22, the National Police Unit obtained information from the Territorial Military Registration and Enlistment Office about your evasion from a military service. Can you explain this? Actually, I provided my explanation to the AGE on this matter. We know that, but could you please provide oral explanations now? Could you please mention whether you were held liable for committing an administrative violation? No, I was not. I was never held liable for an administrative offense. So the fact that the military service addressed to the National Police Office came out as a surprise to me. So actually, I was informed by the police about this situation, and I was very much surprised because I cooperate closely with the police, and I often come to the police office for my professional activities. Frankly speaking, I cannot understand why the head of the military registration and enlistment office would do that. I have my official registration address. I have my official mailing address. I can be easily identified, and if the military office was willing to send me any documents, they could easily find them. So after having clarified the situation, I was reassured by the police that there were no grounds to hold me liable for any administrative offense. Besides, I wanted to actually challenge this decision of the military and this submission done by the military enlistment office to the police because I was never contacted by them and I didn't receive any summons from them. Thank you. I will now turn it over to Maureen.
Final questions here for you. From your responses to the advisory group of experts questions and from open sources, it is known that in addition to participating in the competition for the position of judge of the Constitutional Court of Ukraine, you're also participating in the competition for the position of head of ARMA, the competition for the vacant position of judge of the Specialized District Administrative Court, and the competition for the position of Director General of the PJSC, Yerdo Nergo. Please indicate the current status of your participation in all of those mentioned selection procedures.
Дякую за запитання. Відповідаю.
Thank you very much. Speaking of the competition to Ukrhydroenergo, the competition is over, and I was not shortlisted. I was informed on this in writing, and I provided information on this to the advisory group of experts. So this competition is over for me. As to the competition to ARMA, unfortunately, when I underwent the practical examination stage to ARMA on the 24th of March, out of 13 candidates, only one candidate got to be successful, and I was not among the successful candidates, so this competition is also over for me. Now, speaking of the competition to the Specialized District Administrative Court, I have been invited to take part in the check of my historical knowledge on the 4th of April and professional knowledge check on the 14th of April.
In light of this, please state what your immediate motivation is as of today for participating in the competitive selection of candidates for the position of Judge of the Constitutional Court of Ukraine. You do have another opportunity, as you said, with the Specialized District Administrative Court, and that's upcoming, but you also are participating in this competition. So what's the motivation here?
For me, participation in the competition for the position of a Justice of the Constitutional Court of Ukraine is a priority one. It ranks number one on my list of priorities. What is my motivation? I think that I could make a contribution to the work of the Constitutional Court of Ukraine. The experience and my practical experience while working with the most vulnerable groups of population that, in my deep conviction, needs the most protection. And I am very well aware of the fact how difficult it is for this category of persons as IDPs, militaries, families to defend themselves when the norms of the Constitution, in the light of the position of certain officials are inactive. Therefore, as a practitioner, not as an academician, but as a practitioner, as a person who has been working for years with the real problems, with the most challenging life situations among people, they would be able to show that to the CCU to make this message heard and make them heard there. So I think that my experience and my knowledge would be useful and important for the Constitutional Court of Ukraine. Therefore, I am trying to get this position.
I have no further questions. Mr. Yaroslav, do you have any further questions?
No further questions. Thank you.
Questions from any other members?
Dear colleagues, given that no other EG members have any questions to ask, dear Mr. Sviatoslav, you can take the floor and deliver your closing statement. I thank you for your questions, for a chance of being heard, and given the time that you dedicated to me. I understand that for you and for me that is important. You really wanted to hear me, and I'm hoping that I was able to answer your questions and dispel any doubts that you might have had regarding my candidacy. I'm very grateful to you for a chance to be heard, and I think and I hope that I will see you again. Thank you.
Дякуємо вам за відповіді. Шановні колеги і громадськість, на цьому співбесіда з кандидатом на посаду судді Конституційного суду України Онищуком Святославом Петровичем оголошується завершеною.